Great. Well, welcome everyone. My name is Helen Meyer. I have the pleasure of being the Development Director at Pine Tree Legal Assistance, and I will be moderating the panel presentation today. I'm joined by a great panel of experts from Pine Tree Legal Assistance. We have Katie McGovern, the Directing Attorney in the Portland office, Katie Childs, the Directing Attorney of our Augusta office, Hillary Knight, who's a staff attorney in our Bangor office, and Mary Murphy, a paralegal with our pro bono program. So today we'll be hearing from these staff around the program about what they're seeing on the grounds with evictions. Before we get started, I just want to cover a few housekeeping things. To minimize background noise and disruptions, we're going to keep participants muted for most of the presentation. And I hope people will use the chat function in Zoom to submit questions. And we'll be checking in on those and asking them as we go. And at the very end, if we have time, we'll unmute everyone so that anyone who's participating by phone will also have a chance to ask questions. If we run out of time, just send us an email with your questions after the event, and we'll be sure to get right back to you. The event is being recorded, and we'll share it after, so that if you've missed anything or if you want to share it with a friend or a colleague, you'll have that opportunity. So look for that email from us. And at the end of the conversation, we will be raffling off a gift certificate for Coffee by Design. You don't have to be present to win. I will follow up with the winner after the event to make arrangements for that. All right, so with that, I think we'll go ahead and get started. I know we have a lot that we want to cover today. And to get us started, I think, Hillary, I'm going to turn to you. And could you describe what the eviction process was like pre-pandemic, what happened since March, and what's going on briefly right now?
Sure, thanks. I'll just start by saying that occasionally a fire truck will go by, so I might just have to stop if that happens. You can get a little bit loud here. But okay, so evictions in what I think of as the before times, before March. I typically start talking with clients about this, or non-eviction advocates as a three-step process. Each step can be broken down into many smaller parts, but in general, I think of it as these three events that happen. So most lawful legal evictions start with a notice to quit or a notice of termination. And what's contained in that notice really depends, first of all, on what kind of tenancy it is. So you can have a lease, you can not have a lease. It really depends. And a notice to quit usually will tell you the reason for an eviction. So evictions can happen for all kinds of reasons. They can happen because somebody has fallen behind on rent or stopped paying rent. Sometimes we call that a non-payment eviction. They can happen because of a violation of some term in someone's lease, some problem that's come up with the tenancy. And in certain types of tenancies, you can have a no-cause eviction. Landlord does not have to give a reason. They don't necessarily have to even have a good reason. They can just opt to terminate a tenancy. And that happens in what's called a tenancy at will, where there's no lease or there's just a simple rental agreement that doesn't lay out a timeline. And in general, before sort of COVID events, that would be a 30-day no-cause notice is how we would talk about that. And so the notice to quit can be served by the landlord in very particular ways. Sometimes the way that it's served is laid out in someone's lease. Sometimes it's laid out by statute. And it depends, again, on what kind of tenancy the person has. But the notice to quit is what starts the process. I think of it as the first step in this three-step process. The second part of an eviction is a bigger, meatier part, and that starts with a summons or a complaint. Summons and complaint get served together usually. And it's important that that happens once the notice to quit expires. The notice to quit also will tell the tenant when the landlord expects them to move out. And so after that date has passed, then the landlord can serve the next part of the process, the summons and complaint. Those documents are really important because they formally start the lawsuit of an eviction, and they also tell the tenant when and where their court hearing will be. They contain other pieces of information that might be relevant to that particular case depending on the circumstances. But what's important to know is that evictions in Maine are governed by a set of statutes that are very strict, and landlords really have to comply strictly with the rules that are in those statutes. Those statutes tell landlords exactly what language and what terms have to be in a notice to quit, exactly how it has to be served. And it's important that all of those rules are followed because that's due process. That's what's protecting a tenant's right to the entire process. Once you get to a court date, typically there's mediation of some kind. And I think mediation is one of the most important parts of the process. Both sides, a tenant and a landlord, have a lot of incentive to try to reach an agreement that everybody maybe isn't happy with, but that everybody can live with. Because from a tenant's perspective, and I'll talk about the hearing process, but if you go to a hearing and you're not successful, you have a very, very short window to move out. From a landlord's perspective, if they haven't strictly complied with each and every one of the rules and they can't present their case in the proper way to a judge, they might lose their hearing and have to start the process all over again. And so both sides, through mediation, can try to reach a settlement agreement that'll allow everybody to have some certainty about when this tenancy is going to officially end. In Maine, we have mediators available at the courthouses who are neutral parties. They're not representing either side. They're not a judge. They can't provide legal advice, but they are trained and really good at helping each side identify maybe the weaknesses in their case, potential defenses, reasons why a settlement's a good idea, and try to help facilitate a conversation between the two sides. And often when people get to court for an eviction, it's an extremely tense and traumatic event. And so helping the parties work together is a really important thing. I think mediation is probably where the bulk of the sort of, if there can be any positive outcome, that's usually where it happens. And then the third part of the middle part of my three-part process is a hearing. So if the two sides cannot reach an agreement through mediation, through negotiating with each other, then the case can go to a trial in front of a judge. That hearing is sometimes a little bit difficult to prepare for because unlike a typical lawsuit, you don't have access to all of the evidence necessarily ahead of time. You can never really predict what somebody's going to say. It can be a short hearing, and it really depends on the facts and what's going on in that particular case. But it's important to know that judges don't have very much discretion in these cases. So even if somebody has really difficult circumstances or really compelling reason why they should be able to maintain their housing, the judge doesn't have any ability to change the timeline or as long as the landlord has complied with the statutes and the terms of the lease, then the judge will issue a judgment and there's really nothing else that you can do to advocate at that point. So I try really hard, I think a lot of our advocates try really hard to work with mediators and to work with the other side to see if something can be worked out. But often trial is necessary, and that's where those really strict rules come into play. The final part of the process is after a judgment's been issued in favor of a landlord. So if the plaintiff, the landlord in the case, is able to prove all the elements of their case and get a judgment from the court, then a writ of possession is this document that just says this property, this rental property, the possession will return back to the landlord. That'll issue from the court 7 days after the hearing, and then it needs to be served by a sheriff. And once it's served on the tenant only has 48 hours to move out. So the minimum amount of time that a tenant can have after a hearing is about 9 days. And that's a part of the process that not a lot of people get to see. The judge certainly won't see that part of the process. We don't often see that part of the process ourselves, but that's where once the sheriff serves that and the 48 hours goes by, if the tenant is still maintaining possession of the property and is still living there, they can at that point be arrested for trespassing. It can be a really traumatic process, and it's the final step, and we try to help clients prepare as best as they can to know when that's going to happen, to know exactly when that last date is that they can be at the property. But it's when the case is the eviction actually happens, the physical eviction. So those are the, I think of those as the 3 parts of the main process for a legal eviction. That's how it's supposed to go. Helen, can you remind me did you ask about?
Yeah, I was just going to say, so that's what was happening pre-pandemic when things started to shut down in Maine. Can you tell us a little bit about what happened? Were people still going through the eviction process? Were there any laws out there to protect them?
Yeah, so there were cases that were pending. There were cases waiting for their trial dates. There were cases on the dockets. And on, I think it was March 13th, it was a Friday. I remember that really clearly because I had cases scheduled for trial on Monday. The Maine Supreme Judicial Court issued the first pandemic management order, which announced that the courts would be closing and that the eviction cases in particular would be continued to some date in the future. I think a little bit about that time, thinking like, I wonder if it'll be a week or 2 weeks. We really had no idea how long that was going to last, but there was a momentary sigh of relief that those clients who were waiting for their hearings on Monday didn't have to see the judge on Monday. But then immediately, I think right after I sort of breathed a sigh of relief that there was going to be this continuance and we would sort of figure out the next step on Monday, I think a lot of us sort of realized right away that this raised a potential for landlords to start doing illegal evictions, an unlawful eviction where rather than going through the proper judicial process, a landlord takes some action to try to remove a tenant. And so I think a lot of us started talking about that risk that not having a court process available was going to present, and we all just sort of watched to see what the next thing from the court would be. The Supreme Judicial Court of Maine is also the body that governs how the trial courts operate and what their processes are. So that's why they have the authority to issue these orders about how cases will be heard and when they'll be heard and what kinds of exceptions exist. And separate from that, the governor started issuing executive orders. I think the first one was in April, which talked specifically about the risk of illegal evictions, talked about exceptions that landlords could use to bring an eviction case formally through court if they felt like there were compelling reasons to do so, and what the process should be if somebody wanted to try to get their case heard, bring their eviction case to court before the courts reopened. That order talked about law enforcement's ability to enforce the illegal eviction statute. And between the pandemic management orders issued by the Supreme Judicial Court and the governor's executive orders, there was sort of this labyrinth of rules created that we were all trying to sort out about when a case could get to court, how it would get there, and what new rules would be in place to protect tenants. Because of course, as we all know, in addition to these state rules, both by the court and by the governor, there was a massive federal law passed. The CARES Act created a federal eviction moratorium, and we were all sort of trying to figure out what the terms of that were. The big thing that the CARES Act did with regard to evictions was that it stopped evictions that are federally subsidized properties. That includes public housing, federal and federally backed mortgage properties. So it could be a private landlord, but whose property is subject to a federal or federally backed mortgage. And so it was clear at that point that clients or potential clients who were in public housing or who had Section 8 vouchers would probably be safe from non-payment evictions. And I talked about that a little bit earlier, that in a non-payment eviction, the real issue is whether somebody's behind on their rent. Of course, there's all kinds of other evictions for different reasons. And so we were sorting out what the exceptions were in the CARES Act for clients who might be evicted, not just because they fell behind on rent, but for some other allegation. Like I said, it's been a process, I think, over the last several months of sorting out these different rules, both between the pandemic management orders, the governor's executive orders, and the CARES Act, trying to figure out which rules apply to which cases and how we can use those rules to try to help primarily just keep tenants in their housing as long as possible until they can find new or stable housing. Now the courts are starting to reopen and hear cases again. And that's been, I think it's been a little bit rocky, partly because we had a date in mind about when the cases would be heard again, and courts started scheduling cases. We didn't know if they'd be in person, we didn't know if they'd be telephonic, and then there were new pandemic management orders governing how they'd be heard, and there would be telephonic status conferences, and some cases were already scheduled for in-person hearings. And so it's just been a little bit of a, I guess a little bit of a scramble to figure out how and when your case is going to be heard, whether it'll be on the phone, be in person, whether mediation will be available, will it be the same day. And it's a little bit about going with the flow, but it's also just trying to figure out what the issues are in your case. And it's very specific to each individual case, because you want to find out if the CARES Act governs your case, if your case is affected by that moratorium. You want to figure out if the landlord in that case served the right kind of notice, because some of the executive orders extended the timelines for types of notices that landlords had to give. The motions that some attorneys were filing on behalf of landlords to try to get cases heard before the courts reopened, did they have the grounds to do that? And sort of picking and choosing which rules affected which cases and trying to identify which issues. It was sort of an issue spotting, not a game at all, but it's difficult for sure to keep in your head all the different rules that are in place right now. So I think we have a lot left to see as the courts start hearing more and more cases. I think we're all starting to see a ramp up of cases. I think initially, just for my own self, I was seeing a lot of cases that didn't seem like non-payment notices, which is what I was expecting to see. But now more and more you're seeing non-payment cases, and trying to figure out how you can get the information that you need to identify which rules might protect which tenants in which cases.
Great. Thank you so much, Hillary. That was so much information that you shared with us. So thank you. So Katie McGovern, I want to turn it over to you. With all of the safety protections and changes to the process that the court is implementing, can you tell us a little bit about how Pine Tree is changing its approach to evictions?
Sure. So we, in normal circumstances, we have all of the cases that we get through our intake system through people who call. And then before COVID, we had lots of cases that we developed through walk-ins as well. And then we also, on the day of court, in most of our busy eviction courts, we would be available to pick up cases at court. So people who had not, for one reason or another, had a chance to speak with us ahead of time would be able to talk to us at court, and we'd be able to represent them that morning. The changes in the court system and the fact that we're not able to do walk-ins intakes has meant that we've had to change our approach to try to make sure we are helping as many people as possible. So we've had, since the beginning of the shutdown period, we've added a phone shift so people can call in on Fridays, in addition to all the other times that we've always been open, in order to try to be more available to people by phone. We've also been very involved in the court stakeholders group and any opportunity that we've had to try to let the court know about the concerns of our clients and about low-income people in Maine, in order to influence the way that the process has been rolled out. So for instance, the notices that are being sent to tenants with their summons and complaints explaining this new process includes information about how to reach legal services for the elderly and all of Pine Tree's offices. So we're hopeful that we will be able to let tenants know that we are available and able to help them with their cases and to figure out this new process. We also are developing an information session that we're going to be offering and working on the court to develop, so that people can find out about the process and then also find out about their ability to connect with Pine Tree. So those are the ways that we've been trying to increase our ability to reach tenants so that we can help as many people as possible. We have staff has been developing flyers to put up in places like laundromats and other places that our clients might see them, in order to let them know about their ability to connect with us. And we have, of course, we've been doing a lot of work internally to make sure that we stay up on all of those different overlapping legal issues, as Hillary described. So the other thing that we've been spending time on is making sure that all of our staff are up to speed on all these different overlapping legal issues, so that we're best able to give advice to people who contact us.
Great, thank you so much. So Katie Childs, I'm hoping you can, I know you've been back in court, and the Augusta service area covers several different courts. So could you tell us a little bit about what your experience is being back handling evictions in court this month?
Sure. So it has been very interesting as courts have reopened for evictions, and also very chaotic for some of the reasons that Hillary described. As the court has rolled out this new procedure that sort of changes the stages of the court process in order to really try to help folks avoid having to go to the courthouse and all pack in the way we usually would. Some courts have sort of taken a bit of time to all get on the same page and to actually enforce the new procedure. So in at least a few courts, there have been in-person docket calls, which Hillary had mentioned, and courts have held eviction hearings without first doing the telephonic conference. And so it seems that as those information sheets explaining the new procedure have rolled out, that the courts are now consistently enforcing the new procedure, but it certainly contributed to this sort of sense of chaos with the court process as folks started to have to actually face evictions again. And so I think that what has really been obvious in these first few weeks is that the stakes feel higher for our clients. And even in the before times, the stakes are already high in evictions because tenants are facing the possibility and the likelihood that they may have to leave their home with their family and everything that that entails. And it can be very traumatic and really stressful. And right now there's still a pandemic going on. And so the risk of homelessness has even more drastic consequences for families. And there are additional financial struggles and challenges with the rental housing market and finding safe and affordable housing. And so, so I would say that it's palpable that the stakes feel higher for our clients. And emotions are heightened, I think, on both sides. Landlords have had to wait months to have their cases heard. And so you get the sense that they, in many cases, feel that it's unfair, and that that might mean that they're less likely to negotiate to give tenants additional time or to try to work something out, because they already feel that they have had to wait so long. And for tenants, I think that many of them have expressed that they don't understand how they can be evicted right now. They don't understand how it can be possible that they might be homeless during this pandemic. Also, as Hillary mentioned, you know, the eviction process itself is really technical, and even more so now with the CARES Act and with the governor's orders and all of the new sort of requirements. There's just a different analysis, and if the landlord hasn't followed the CARES Act or the new procedures, that may give rise to additional defenses that we, you know, haven't had in the past. And as we have hearings and defend cases on, you know, that basis, we will, there are, those are other tools that we can use to help tenants possibly get additional time. But it also is more difficult now to tell our clients, you know, we for sure know that this is going to be a slam dunk defense in your case, or that the judge is going to agree with our interpretation of the governor's order, because this is new to us too. So it can be difficult to predict exactly how things will happen. And with the new procedure, the scheduling is not predictable anymore. So in the past, we knew if someone is facing an eviction in Skowhegan, we could look at the schedule of cases for the next 3 months in Skowhegan, and we could tell them, you can't be brought into court until this date. And so if you have a hearing, then your worst case scenario is you have 7 days from the court date until they can get the writ of possession. And then it has to be served on you, and then you have 48 hours. And it was, you know, we could really give people their worst case scenario timeline, which often is awful news to deliver, but at least people have certainty. And now with the telephonic status conferences, we don't know when those will be scheduled. It's not necessarily the case that, you know, Skowhegan will have their conferences every Monday. And then we don't know exactly when those cases will be sent to mediation, and then when final hearings will be held. So it's difficult for us to predict for our clients what they can expect. And of course, we can't cover all of the courts. And so we can only take on so many cases and cover as many courts as we can. And so it's really important and wonderful that folks who are receiving the summons and complaint now have our contact information, so that even if we can't cover that court, they can call us and get some, you know, information. But we are trying to cover as many cases as we possibly can.
Great. Thank you so much, Katie. And I want to jump to a question that someone submitted in advance. And the question is, are all poor people represented by counsel?
They're not. So in Maine, there is not a universal right to counsel in all civil cases. In 2019, Pine Tree only handled about 18% of eviction cases. There were more than 5,300 eviction cases in Maine in 2019, and we can only handle a percentage of those. There are some jurisdictions where there is a right to counsel in eviction cases, in New York City and San Francisco, but unfortunately not in Maine.
Thank you, Katie. And while I'm going to just harp on you just a little bit more, if you don't mind, we had a question from Shanna Bellows. If a constituent is facing a non-payment eviction, does Pine Tree have the capacity to take on the case, and what resources are available for them?
So, that's always our hope, that we can take on all the eviction cases that come our way. And certainly everyone who is facing an eviction should call us to find out if we do have capacity. We can't ever guarantee it, but we want to, like I said, we want to represent as many tenants facing eviction as we can. And so that is a very high priority case for us. And the resources that are available, if someone has no income, of course, they can apply for general assistance for help with rent. And then also Maine Housing has the rental assistance program. And the contact information for Maine Housing is also in the information sheets that's being sent to tenants, so that folks can find out if they're eligible for that rental assistance. It's limited, so for many folks, it's not going to solve their entire arrears or their rent going forward, but it isn't a very important resource that's available to tenants right now.
Oh, thank you so much, Katie. I appreciate it. So I'm going to turn back to Katie McGovern. Katie, we've heard a lot about the cliff of evictions or the avalanche of evictions that experts have been predicting. One of my biggest questions is, are we seeing that in Maine yet?
I don't think we've seen it in Maine yet. I think right now there is a high volume of cases that we're handling because we're handling the cases that were filed before the shutdown or soon after the shutdown. So each of our offices right now is handling a high volume of cases as all of those cases get pre-tried and then set for hearings. So it feels really busy right now, but I don't think we've seen the large increase in filings yet. And I think some of the reason for that may be that only recently did folks lose the extra pandemic unemployment. So I think we haven't seen the consequences of that play out yet. We know that people have been doing their very best to hold things together and prioritizing rent because housing is a public health issue, as we all know right now. So I think that we have not yet seen that. We may see it as people's, the impact of the loss of unemployment if that remains the way it is, or if there's not more assistance. We know that the rental assistance through Maine Housing, of course, is playing a really important role right now. And hopefully there will be enough rental assistance for that.
Great, thank you. And how are evictions impacting children? And one of our participants had asked specifically under the McKinney-Vento Act. So Hillary, maybe you could tell us a little bit about that.
Sure. So I think in general, both research and our experience anecdotally tells us that an eviction itself is devastating and traumatic to a family and particularly to children. If you're interested just in reading really well done and readable research about the effects of eviction on families and communities, I would highly recommend the book Evicted by Matthew Desmond. It does a really great job of sort of painting pictures of what it looks like on the ground to be evicted. In my experience, and I think my colleagues would agree with this, that our clients, particularly families, they always have competing concerns. They have lots of things going on in their lives. People's real life doesn't look like siloed legal issues. And it can feel sometimes as a lawyer like, what's the legal question in front of me? What can I prove in court? What's the trial on this one issue going to look like? But for our clients and for families, there's lots and lots of things that they're dealing with and struggling with. And sometimes the eviction itself can be part of that, but sometimes it's also, where are my kids going to go to school if I get evicted? If we get evicted, where am I going to stay tonight? And that can be a separate problem to solve than simply what's the best defense in this case legally. And so we will often hear from our clients that their primary concern is their children. Excuse me. In Maine, children have a right to a public education, and that means that if a child is unhoused or homeless, they have the right to go to school, and they have the right under the McKinney-Vento Act to, if they become unhoused or homeless, they have the right to stay in the school where they were before that event happened, or to attend school where they are now living. I don't particularly work with that act myself in my day-to-day work, but Pine Tree has the Kids Legal Unit, which works on that issue in particular, advocates for children's rights to an education. I encourage you, if you're interested in that question, to check out our Kids Legal educational materials at kidslegal.org. We have information about the children's rights to an education. But in my work, particularly with eviction defense, for parents, it's their highest priority usually. What's going to happen to my kids? How do I keep them in school? For example, right now I can think of two cases I have right now where I have two separate cases, they're unrelated, where my client is a single mom. In one case, my client has two high school age children. She's being evicted and her children are in high school. It would be really painful to switch school districts. She would really like to stay in the school district, but she lives in a very rural part of central Maine, and to find affordable housing within that school district is just nearly impossible, and certainly impossible on the timeline that the eviction seems to be processing. So the realistic possibility of finding affordable housing in a place where her kids can stay in the school where they are is just, it's the number one most important thing for us in this case, trying to make sure that she has enough time to try to find some place to move with her kids. In my other case, my client's a single mom who has a elementary age child who has special needs and has been absolutely thriving in his school. He has the support and resources for the first time to get an education and to do really, really well. And that's showing in their experience, it's improving other parts of his life to have a stable and well-resourced school experience. And she's facing an eviction. And the idea of having to move outside of that school district, because she lives in subsidized housing. So in order for her to try to find other subsidized housing might mean that she has to move to a different public housing authority, another jurisdiction. And the idea of taking her kid out of school in order to do that it's the single most important part of that case to her. And it's a really difficult thing for our clients. And sometimes that means our work looks not just like analyzing the facts of the case for the best possible defense, but trying to link our clients with resources that can try to help them manage those other competing aspects of their life, the other problems that they're facing. So sometimes, we're attorneys, we look at cases as legal questions, but there's, a certain aspect of our work that's more akin to social work, trying to help our clients access, Katie was mentioning sort of the rental assistance programs that might be available in individual communities, trying to link clients with the nearest shelter program, trying to make sure that clients know where general assistance is available, how to reach it when the town office is closed. How do you get a hold of a general assistance administrator? How do you apply for general assistance? What happens if you get denied or told that you aren't going to be eligible for general assistance? Just sort of managing this event that happens that just throws your whole life into chaos. And I think for us, it's about what's most important to our clients. We don't tell our clients what's most important to them. They tell us what's most important to them. And so if a client says, I need to stay in the school district, I don't want my kid to lose all the progress he's made at this school. I don't want my senior in high school to have to switch school districts right now. And on top of all of that, these students are dealing with the chaos of schools reopening. And it can feel like one thing piling on top of another. And so trying to help clients as best we can with our resources. Obviously, I'm not a trained social worker. I'm not, I don't know everything that's available out there. I don't know what all the best resources are to send clients to, but you know, you just, with the limited amount of time that you have and the volume of cases that we have, just trying to prioritize a client's interest, what they're telling you their number one interest is the, but in terms of the children's rights to stay in school, it's not my area of expertise, but we do have the Kids Legal Unit, and I just really encourage you to reach out to them and check out their educational materials, because I know that I've heard about work they've done advocating for students who have the right to stay in the school where they are if their family becomes unhoused, particularly due to an eviction.
Great, thank you so much, Hillary. And I did include a link to the Kids Legal website in the chat, so people who are interested can go there to get more information and give us a call. Kids Legal is a special project within Pine Tree Legal Assistance that's focused specifically on the needs and rights of children. Mary, I want to turn it over to you. We haven't heard from you yet. I know that we've been getting a lot of requests from people, lawyers, and also other people in our community who are concerned about homelessness and an eviction crisis. How can lawyers and other volunteers in the community help us out?
Well, we're very anxious to hear from people in the community, attorneys and non-attorneys, who might be interested in volunteering to help with this crisis and the expected avalanche of evictions. The pro bono program at Pine Tree is currently staffed by myself and our program director, Shannon Karam. With all the changes to court procedures that we've just been discussing, we are giving a lot of thought to how best to plug in volunteers to assist tenants, low-income tenants facing eviction. We're not sure exactly what some of that's going to look like, but we really want to hear from folks and get you on a list. And I can talk a little about some of the opportunities that we are thinking will be available. So for non-attorney volunteers, one possibility might be to help staff those remote group information sessions for eviction defendants that I think Katie McGovern mentioned. It's also possible that we may use non-attorney volunteers to help field intake calls for evictions if depending on what increase in call volume we see. And as someone who also helps staff Pine Tree's call center, I know, Katie McGovern said we have a high volume now, but we haven't seen the huge avalanche yet. However, I would say from the intake perspective that our intake lines are getting busier and busier. And so I'm worried that that volume is going to continue to increase. For attorney volunteers, we were thinking we already were setting up a FED defense project before the pandemic that was focused in part on having volunteer attorneys assist with court pickups, especially in courts that Pine Tree staff attorneys do not have the capacity to cover. Right now, we're working to modify that project to have less emphasis on court pickup cases, given the new procedures. Our vision is to instead work with a small group of attorney volunteers to provide full representation on individual eviction cases that we receive through our regular intake process. We would ask those attorneys to commit to accepting 1 to 2 eviction cases on a bi-weekly basis for a 6-month period. And we would provide training and supervision to volunteers willing to make that commitment. There may also still be the possibility in some cases of going to court to help cover in-person eviction dockets for those who are willing to consider that. We just have to wait and see, as the staff attorneys already mentioned, how that's actually going to play out and how the courts are going to be scheduling mediations and hearings before we know if that will be possible. And because, of course, we expect to have more individual requests for eviction help than our staff attorneys will have the capacity to cover, there is always a need for attorneys who already have housing experience to be available to accept individual pro bono case referrals from us, or the very important role of mentoring other volunteer attorneys who want to work on eviction cases. So our pro bono program's Eviction Defense Project has been offering and will continue to offer trainings and updates to interested attorneys. The next pro bono evictions training is tentatively planned for a half day on Friday, September 25th. So we encourage you to please get in touch with us, and that goes for community volunteers as well, if you have any interest in assisting with what we hope will be an all hands on deck situation. I see that Helen has already put my contact info in the chat, and I will put Shannon's as well.
Great. Thank you, Mary, and thank you too to everybody who has already volunteered to help out or who asked about ways to volunteer on the registration form for this event. We appreciate it. One of the questions that was submitted in advance was stemming about landlords, and a question specifically about financial difficulties for landlords, especially on properties owned by small individual investors, and are there any programs to deal with this issue? Katie McGovern, maybe we could have you take a stab at answering that question.
Well, we know that part of the CARES Act included moratoriums on foreclosures and forbearance programs offered to homeowners and including landlords. So I think landlords should definitely take a look at those programs to see if they would be eligible for assistance through the CARES Act. We also know that, of course, the rental assistance that's coming through Maine Housing, or the rent that's being paid through the town offices through general assistance, of course, goes directly to landlords. So all of those, that assistance program benefits landlords as well. And of course, keeping tenants in their housing is a benefit to landlords if they can avoid having to go through the eviction process. So rental assistance benefits both sides of the landlord-tenant equation. And of course, it benefits all of us for people to be able to remain in their homes during a pandemic.
Thank you so much, Katie. We have two questions from Nick at the Bangor Daily News. So Hillary, maybe I'll ask the first one to you. Are you seeing regions where new eviction cases are generally located?
So it's really hard to say whether, one region of the state is more affected or less affected by the eviction crisis. I think Maine has really distinct regions that have really particular issues that are particular to that region. And so it's not that one region's more affected or less affected than another, it's that they're facing really different obstacles and problems. So I know that we keep a close watch on our intakes, where we're getting calls from, where evictions seem to be coming in from. And I think it's been proportional to population in those areas. But as an example of sort of the different ways that communities and regions of Maine are affected, in southern Maine, there's a higher population, there's a lot more rental housing that would tend to make sense why there's just a higher volume of evictions in southern Maine. And that alone is a huge, huge problem. In central and northern Maine, where I work, we have a proportional rise in evictions right now, but some of the issues that are a little bit different here are that particularly in rural communities, so statewide, I think there's just an absolute lack of affordable housing. Housing is getting less and less affordable. Rental housing is becoming harder and harder to afford. I know that from HUD's perspective, the affordability ratio in southern Maine and northern Maine is about the same. That means, you know, the average income and the average cost of renting is basically similar. But for our clients up here in central and northern Maine, if you lose your housing, if you are evicted, it's extremely difficult to find rental housing that you can afford within the community where you've been. You might have to move to an entirely different town, an entirely different city, and like I said before, an entirely different school district, because it's very hard to stay local because of the lack of affordable housing and how spread out housing is. I think we're going to know more over the coming months. I think it's hard to say right now sort of what the spread is going to look like throughout Maine. And I think one of the best things about Pine Tree is that we have offices around the state. Our offices are located in different regions of the state, and our attorneys you know, live and work in the communities where our offices are located. And so I feel more knowledgeable about what's going on in central and northern Maine than I know about what's going on in southern Maine. But I have colleagues in southern Maine that I can talk to about what they're seeing, what's happening in the courts there. And it's just critically important that our offices are, you know, that we have staff in all 6 of our offices so that we can individually try to represent and help and give advice to clients throughout the state, whether they're dealing with not being able to find affordable housing nearby, or whether they're dealing with, you know, a different issue in their community. That's my, you know, I think my favorite thing about Pine Tree is being able to call somebody in the Lewiston office or the Augusta office or the Presque Isle office and talk about, you know, their strategies, what resources are available there. Sometimes clients move from, you know, the Bangor service area to the Augusta service area, and I can call colleagues in the Augusta office and say, you know, this client, after being evicted here, moved to Skowhegan and now has a new legal issue. Is this something that you have the capacity to help with? So it's good to have a network throughout the state. It's just really important that our offices, you know, are staffed and we can take as many cases throughout the state as we can, because I think no matter where you are in Maine, we're seeing an uptick in these cases, and it takes a particularized view of what issues are affecting that person and that community.
Great, thank you so much, Hillary. I appreciate it. Second part of Nick's question, we'll just open it up to anyone on the panel who wants to take this one. Could you talk a little bit about evictions in properties with federally backed mortgages and whether you're seeing an uptick there after the moratorium has lifted?
I can answer that, Helen, to the best that I can. So we're seeing an uptick in all cases. It's difficult for us to know whether a landlord has a federally backed mortgage generally. So that was a concern about how we would allege or find out whether someone's mortgage was federally backed, because even if you can find the mortgage document through the Registry of Deeds, it doesn't necessarily tell you whether it's federally backed. And so the court has now required that landlords certify whether they the CARES Act applies to their property. And so that will be obviously very helpful for us in assessing whether the CARES Act does apply. But I think that it's hard for us to really say quite yet or track trends, because it's also recent that we've been back in court and that we are seeing those landlord certifications. So we definitely expect an uptick, but I don't think we can quite say yet to what extent we're seeing it in our cases.
Thank you so much, Katie. I think we'll just take one more question and then we'll wrap it up for today because it's almost 10 o'clock. This is from someone, the question is, we had a few families in which the landlords sold their properties and with little notice to the tenants. Do those tenants have any recourse after being evicted?
When a landlord sells a property, if the tenant has a lease, the new owner takes the property subject to that lease. So that's always the first thing that we look at when someone calls us about learning that their building has been sold. And then of course the landlord, if they're trying to evict, still has to go through the regular court process. And so the landlord would have to give if they were going to give a no cause notice because someone's lease had already expired, they would have to give the notice that complied with the governor's current executive order. So those tenants should definitely contact us and we can talk them through their individual situation and see what can be done and what timeline they're looking at.
Was that a question about personal property or about the housing itself?
That's a good question. I don't think they specified in the question. Let's see here. Yeah, Celia, if you wanna, I'll just unmute you and then you should be able to ask your question here.
Yeah, so it was a personal property that the owner sold, but had been previously renting. And so 2 families got displaced because of that. And they had very little notice. I think it happened right when COVID had happened. So right after March 13th, 2 families became displaced because the private sale of private property.
I thought maybe you would have been, I must have misread the question. I thought you might have been asking about the process for sometimes after a tenant is evicted, if it happens really quickly and they don't have an opportunity to move their belongings out of their rental housing, there's a process that's laid out that involves notice and pretty strict rules about notice to tenants about their personal property that's left behind. And that's something that we sometimes are able to walk clients through the process of trying to retrieve personal property after they've suddenly had to move or been evicted. So if you see that issue come up, it's something that people can absolutely call our call center about, at least for advice about the sort of step-by-step process that landlords are supposed to go through if somebody leaves behind personal belongings. Just a separate, different problem that tenants face.
So it sounds like you're talking about people who were already required to leave and have already left their housing. And so I think that question would be about whether there is recourse for people who have been illegally evicted. So if the tenants were forced out, locked out, had utilities turned off, or otherwise illegally evicted, there is the ability for a tenant to sue a landlord for damages, either statutory damages or actual damages that were incurred as a result of an illegal eviction. If the tenants agreed to move, they may not have that kind of claim, but those are also issues that tenants can contact us about for advice.
Great, thank you so much, Katie and Hillary, and thank you, Celia, for asking that great question. So it's 10 o'clock and we're running out of time this morning. If you have questions, please email me or Julia, who sent out the registration forms, and we'll pass it on to the team and get a response out for you. And thank you all so much for joining us today and taking time out of your Friday morning to join us. Quickly, but before we take off, before we wrap up, I just want to do a raffle for the Coffee by Design gift certificates. So we've got the names of everybody who signed up in here today, and I'll just grab somebody. So our winner today is Eric Jorgensen. So Eric, if you're still on the phone, I'll follow up with you by email to arrange for that. And just a quick reminder to everybody, there are plenty of ways that you can support Pine Tree. One is, of course, by volunteering with us, which we always appreciate. So please reach out to Mary Murphy about that. We need as much help as we can get. We have very limited resources. We would also really like your help sharing the information that's on our website and our social media accounts. As our team described, without being able to go to the courthouse and pick up cases for people who didn't know about our services and calls in advance, we're not able to serve as many people. So we need as much help as we can getting the word out. So please share those resources in your community and make sure people are aware of them. And of course, we can always use financial contributions. So please feel free to go to our website and make a donation. And for lawyers who are joining, we always encourage you to support the Campaign for Justice, which is a special effort by lawyers in Maine to raise money for legal aid. So thank you. Thank you all. I hope everyone has a great weekend, and we hope to see you back at another one of these events soon.
Thank you, everyone.